The answer is yes and also no. We've all read articles in the media about various celebrities securing a quickie divorce, but in reality it's something of a misnomer. The media have referred to divorces that used to be based on adultery or unreasonable behaviour as quickie divorces, because you could divorce immediately rather than waiting for 2 years to pass before you could separate without blame. All that changed in April 2022 when no-fault divorce was introduced. Now there is no need to wait or to prove adultery or unreasonable behaviour. One or both parties can apply for divorce without delay, provided you've been married for at least a year. So all divorces have effectively become quickie divorces. However, under no-fault divorce, the process actually takes 26 weeks, so in reality it isn't quick at all. But the timetable for divorce, and in particular the 20-week cooling off period between the date you make the application and the date the court pronounces the conditional order, was introduced deliberately to counter concerns that the new no-fault divorce process would make things too easy for couples to call time on their marriage. The idea is to give both parties time to reflect on their decision and obtain the legal advice they need to resolve other issues such as financial settlement or arrangements for their children. So the process for getting divorced is all done online via a court portal. It's fairly straightforward, although if you have an international connection, you should take some legal advice before issuing, just to make sure that you're divorcing in the correct jurisdiction. The process is started by making an application, which is then sent to your spouse for acknowledgement. Once that has been completed, the court will set a date for pronouncing what is known as the conditional order, and that is the order that entitles you and your spouse to a divorce. Once that order has been made, you can apply for the final order of divorce 6 weeks later. It should be noted that applications for divorce can be made together or by a sole applicant. In some cases, there may be more than one possible jurisdiction for a divorce, and the financial settlement will often be linked to where the divorce proceedings take place. The outcome for that settlement may be different in one jurisdiction rather than another, so it's important to consider where you issue your divorce to ensure you get the best outcome. Urgent legal advice should be taken because timing could be critical for making your application, as often the court will be determined by the first application in time. It's often advisable to delay finalising your divorce and holding off from applying for the final order until such time as you've reached a financial settlement and have had that correctly drawn up and approved by the family court in a court order. If you're no longer married and one of you dies before that financial settlement has been reached, your entitlements to their financial assets may change, and you may find yourself at a disadvantage. If you have any questions or concerns about going through divorce and separation, please don't hesitate to get in touch by visiting the website or sending us an email.